Hello and welcome to this week's edition of Wednesday Wisdom. My name is JB Hilliard and these are our weekly video segments, very short segments designed to give you some answers to some questions related to estate planning, probate, and other legal concerns you may have. And these weekly videos are an extension of our monthly newsletter called Sidebarred. And if you're interested in seeing more about what that is about, you can look right down here and sign up and get that right in your inbox. But for this week, I want to talk briefly about joint ownership in real property. So before I get too carried away, let me get my timer together and get that going. Hopefully this will be shorter than what I've typically been doing, but I still try to keep them in 5 minutes or less time frame. So at any rate, what I want to talk about as I continue to do some work in real estate is to describe or explain joint tenants with rights of survivorship versus tenants in common ownership or title ownership. And basically what that says is, or what that is joint tenancy, to abbreviate it. Joint tenancy means that, and that's typically what married couples do, at least here in Georgia. And that's where you each have a share in the property. And then when the first spouse dies, the surviving spouse automatically gets or retains 100% interest in that property. So they become 100% owner automatically. And married couples typically like joint tenancy ownership because that first spouse to pass away, that property doesn't have to go through probate. So then the surviving spouse has that property as 100% owner, and then they can devise that in their will according to however they want to bequeath that or devise that out. And if there's no will, then it goes through the normal state intestacy laws, basically the next of kin. That's joint tenancy with rights of survivorship. So again, that surviving tenant, that surviving owner has a right of that full ownership, that right of survivorship. Now, on the other side of that is tenants in common. And tenants in common is typically where you have two or more people with wanting joint ownership, and that could be relatives like siblings or a parent and an adult child or business partners even. And the main difference of that is that when you jointly own that property, and typically it's equal ownership, but it can be unequal ownership or unequal interest in ownership. But at any rate, let's just say, see, I knew I was going to run out of time. Let's just say that it's a brother and sister getting together to own an equal share. So each has 50% share. When that first, again, tenant, when that first owner dies, that 50% share stays sort of on that owner's side. So let's say it's my brother and myself as partners. So if my brother dies first, his 50% stays his 50%, so to speak. In other words, his 50% goes through his will, if he has a will in place, which he better, since his sister is an estate planning attorney. I'm still working on that with them. But his will go through his will, whoever he's bequeathed his part to, or if he doesn't have a will in lieu of that, then the state law will determine wife and children, basically. And then I retain my 50%. Then when I pass away, again, his 50% is taken care of. So in my will, it's just that 50% interest in that share of that property. So hopefully that makes a little bit of sense when you all are entering in real estate contracts, particularly as married couples. You want to make sure that the deed is going to state how you're owning that property. It needs to specify, if it's joint tenancy, it needs to say that specifically, joint tenants with rights of survivorship, or joint tenancy, or taking jointly with survivorship, or any of those terms that collectively say joint tenants with rights of survivorship, and not as tenants in common. A lot of times you'll see that written out. Otherwise, the default turns back to tenants in common. And then one other thing, I know my time was up a little bit ago, but one other thing, there's another tenancy or title interest called tenants by the entirety. And that's recognized in other states, in some other states, for married couples specifically. See, I snoozed it. to make sure I gave myself a second chance to be on time here. But that's recognized in other states for married couples specifically. And Georgia does not recognize that particular one. Again, it's called tenants by the entirety. So our version of that is joint tenancy, joint tenants with rights of survivorship. So I know that was a lot for those of you who are really not familiar with how you hold title in real property, but hopefully the next time you enter into a contract, you're buying a property, buying that house, then you'll recognize that and know which way to go. Okay, hope that's helpful, and we'll see you next time. But as always, thank you for watching and have a great week.